Amy, do you have any questions while waiting for them?
Not yet, sir.
Yeah, okay, right.
Right.
Assalamualaikum, Mujahid. Dah makan dah eh?
Waalaikumsalam. Dah sir.
Alhamdulillah.
Alhamdulillah.
Right. Okay. Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. Nuru ma'asmi syamfil a'la fis sama'i wa huwa samil alim. Okay, guys. Good evening. So most of you are coming from group G or what? Guys,
I'm from Group H, sir.
group H. So yeah, Anis. I realized that. Okay. Group G. Ciao. Right. Shall we start, or do we need to wait for the rest? I don't think so lah sebab dah malam Eh, apa ni? How do you turn off the CC, turn off caption?
Uh, on the bottom, next to the
Ah,
you are presenting.
okay. So turn off now. Turn on. Okay. Right. Guys, do you have any questions about the two document or any other documents that you have gone through? Inshallah, we are here to clarify or discuss certain statements that is within the document itself. I dah record belum? Okay. Yeah. Any questions? Any clarification that you wanted to get from me when it comes to the question of whether we are to follow unjust law or not? The first document talks about the validity of the law and the obligation. Basically, we are obliged to follow the law, even though the law is, might be considered to someone as considered as unjust law. You know, not everything of the law is considered as just. Okay, when it comes to just or unjust, normally people will have their own morality standard that they utilize in order for them to say whether the law is just or unjust. But if you allow that kind of interpretation to be done by the society, so or for that matter for the judges to do a conduct of that, then it can be a situation of uncertainty of the law. That is what Hart is saying. So as long as there is some quorum or some basis of the law according to what he is his model he tries to present, which is comprising of the primary and secondary rules, then therefore such laws are considered as just, yeah, in terms of the legality. So even though the content might be seen as a unjust situation or unjust a ruling, we has to still follow because we are obliged to follow that particular law. Yeah. Yes. I cannot gauge your understanding without you telling me or discussing about the things of your understanding. Can I have someone
So
to start? Yes, Anis.
I have a question. Regarding Austin's view in like the law must be in the purest form.
Yes.
Um, I don't know. I don't understand like it by meaning like in purest form. If we were to like remove any external factors, like how would the law first exist? Like isn't like law exist because someone thought that oh this action isn't acceptable by the society, so we must create a law. Or I want to prevent my like people from doing this, so we must make a law. So isn't that like the cause of how a law is created? Isn't it
Mm.
hard to separate between the two?
It is, in a way, it is quite difficult to separate between the two. But as far as the legitimation, once we legitimize the authority, meaning the authority is sovereign, right? So that sovereignty is the position of a person that is able to come up with good laws. So we cannot run away, right? Kita tak boleh lari daripada position that the society have already kita dah translate our willing to surrender to a person that is we consider as sovereign. So any laws that is coming from that particular person, which is the sovereign, we owe the obligation to follow that particular law. Tak tahu. Anis, are you
Uh,
okay with it or macam mana?
I understand. It's just that I believe so Austin punya opinion towards like law, it's like it's actually in a way it's allowing a law to be abused. Like if we get a good like sovereign, I mean
Yeah.
we have good law. Tapi like if we got someone like macam like very bad people yang abuse the law untuk diorang punya self satisfaction semua tu, wouldn't it like open the floodgate untuk
It is.
dia make laws yang benefit dia seorang je?
Yeah, betul. I do agree with you because it all depends on the person of sovereign, right? So whether the sovereign is a good person or not, if a good person, he would try to do his best to provide a good law. But when it comes to a person who is a dictator, who abuse the position and the common sense of coming out with good laws, then definitely we are looking at the trickling of all the negative laws or unjust laws towards the society, kan? Macam kita ambil contoh lah, dictator Hitler, right? I have given, I think, a video, right? If I'm not mistaken, I shared you a video about Hitler, how he comes into power, and when he is in the position of making the law as a person of sovereign, right? So whatever he says is going to be a law that everyone have to follow, even though people realize that the law he created or he forces onto the society to follow that law which he wants, i.e., one of the example is to kill the Jews without any lawful justification, just on the basis of they are unworthy, they cause chaos or problem in the society. So it is justified to kill every one of them, irrespective whether they are women, they are babies, kids. It does not matter. So if you have this type of sovereign, then obviously the sovereign is going to come up with laws that is considered as unjust. That is the question. Remember the case, Nuremberg trials, where we have case of the wife the informer's wife, kan? The wife who informs about the husband. Remember, she wanted to have an affair with someone else, so the husband is in her way, and she told the authorities about the behavior of the husband who likes to protect the Jews. So the husband was sent to the front somehow or other. Uh, the husband managed to survive, and obviously the complainant went to the court, and the court, after the war ended, they tried her, and her excuse is saying that, look, um, the law is the law. I'm not I I am not in the position to say that the law is valid or not. I just follow whatever decision that has been decreed upon us. So how can I be wrong? So that was her argument in court. She is, in a way, is applying Austin's perspective. So too bad, right? We have sovereign who came up with this so-called unjust law, and obviously you have to follow the unjust law. I agree with you lah, Anis, in that sense. Yeah. If we were to follow model, Austin model of to have a valid law, then it will be in the position whereby it opens up to the floodgate, as what you said just now. Open the position of the sovereign to abuse his or her position and to create unjust law. But that does not mean that you are to have the right, because chances are you might be the one that is going to be punished because you are not following the law. That is why kita tengok most of them when they argued this, some of them were not being sentenced because they were followers of the law, not the one that is in the position of high ranking, whereby they purposely, use the situation to abuse their position and follow the unjust law. Some of them were sentenced to death. Some of them were, they had the chance of running away from being punished. Kalau it is better for you to have a look at Nuremberg trials in order for you to understand further. Jadi Anis, macam mana? Any input?
Nampak sir.
Jadi
Not,
jadi susah lah kan. Kalau you nak jawab exam question, if the exam question is asking kata what is the duty of a person to follow or not follow the unjust law, it depends on which perspective that you want to follow. So you have to give different perspective. So you nak bagi Austin, you nak bagi Hart, you nak bagi Fuller, you nak bagi Finis, okay? You nak bagi uh, apa Aquinas, kalau you nak bagi to the extent of Aristotle pun boleh juga, or Plato for that matter.
boleh sir. Like
Boleh.
Aristotle and Plato. Oh,
Boleh. Socrates, remember Socrates kan kena hukum makan racun kan, because he was a victim of the system, right? The government at that point of time hated him, not the government but the society. Some of the members of the society memang tak suka dia, because dia bagi lecture ataupun dia bagi teaching for free, whereas these so-called lawyers, preachers, the art of defending yourself, the art of how to argue in court, it is a practice that is given by the sophists. Kalau you baca sophists, they give this apa dia kata, training, ataupun you have tutor that comes to your house and teach you how to argue, the art of argument, right? And these people are not happy with Socrates because a lot of their students lari, tak mau belajar dengan dia orang, and then pergi kat Socrates, whereas Socrates tak charge pula. So they hate him, right? Because they cannot make money. So they accuse him of corrupting all the youngsters, to go against the norm, and then to corrupt their minds in terms of not believing in God. They have so many gods kan. Tu kadang-kadang orang tertanya-tanya sama ada Socrates seorang nabi ke atau tak, because he did his argument is very close in terms of believing to a superior authority, which is he did not clearly mention some of the writings ada clear cakap, because Socrates tak tulis buku. Yang tulis buku ialah Plato. Plato yang all about Socrates is from his student Plato. Okay, so you can utilize all these people whenever you read their ideas and bring them into the discussion of whether you are to follow unjust law or not. So kalau lah kata you are talking about Austin, you say that I have no way of going against the law because the law is valid. It comes from the sovereigns, therefore I have no right or have no avenue untuk I nak lari daripada uh, following the law. Anis?
Saya, sir.
Yeah?
Faham, sir. I see your input. And I think that like the view of Austin is like, for me, people yang follow the view of Austin is more pada people yang like they're not thinkers, they're more pada followers. They just agree je
Ya,
instead of
betul.
like going against what is stated.
Yeah, going blindly to this. Ini kita nampak dalam kita punya generation, bukan generation, the older generation. The older generation, their whatever laws that has been created by the government, meaning the government that we have previously Barisan Nasional, right? So anything that is coming from Barisan Nasional or especially UMNO, so it is considered as a valid law, irrespective whether that particular law is just or not. As we can see also from the members of PAS, any directive that comes from the people who leads the party, right? So members selalu akan ikut apa yang dia orang minta, or just because they are having that authority nature. Okay, but that one, my example tu yang I bagi tu is not up to the standard lah, whereby we are talking about legal kan, we are talking about sovereign. Nothing law that is above him or her, right? So he or she is above the law. Kalau kita tengok dekat Brunei, Brunei King of Brunei, obviously he is above the law. So does the King Saudi, so he is above the law. Though they say that they are bound by Al-Quran, but it seems that the way it is being implemented, it is not Al-Quran above the law. Al-Quran above the law. Yalah, Al-Quran is the source of law, or Al-Quran as the constitution of Saudi Arabia or even Brunei. So this particular discussion, kalau you can always put it in, depending on your understanding of how you want to argue.
If we were to include criticism inside our discussion,
Yeah.
so will it be like, maksudnya macam soalan jenis apa yang can we include the criticism? So is it like the one yang macam we must explain yang pasal 5 juris tu, can we include the criticism as well?
Yes. Provided that when you talk about criticism, that criticism must be based on after you have mentioned about the jurist. You cannot be criticizing the concept before you introduce the jurist. It must be within the discussion of the jurist. So kalau macam ni, you introduce Austin and talk about his idea, his model, right? His model is saying that the law, you have to be following the law because it comes from the sovereign, and then if we don't follow, there will be a sanction, right? It's a command by sovereign backed by sanction. So after that explanation and giving example of how this sovereign is considered as a proper law for you to follow, then you can add into the example, or bringing in discussion, or even criticizing it. And then you present with another person to give another perspective, so another model. Remember, all these people are not by themselves is valid, ataupun not by themselves is the true answer. There is no true answer in jurisprudence. Don't worry that, oh my god, I'm supposed to find a solution. No, there is no solution when it comes to jurisprudence. It is all depending on opinions. So basically, it is your idea about the law from the jurisprudential perspective. You cannot, all of you cannot be in the position that you want to promote your own personal idea. No, you cannot do that. It must be within the discussion of that particular jurist. If you present hard, you must be talking about primary and secondary, and then you might go against the you macam seolah-olah you you gang up with the people who critics about hard. Then you can do that. Okay, so that is the the role of you whenever you answer examination questions. We don't want to know about your personal opinion. We want to know whether you understand the juries that you are talking about and being able to be critical about that juries. That is good. You agree or disagree is up to you. You can do whatever you want, because juries is, in a way, there is no clear answer, as I mentioned. Okay, jangan risau. Tak, I rasa kebanyakan student when it comes to answering juries, dia rasa macam tak clear, is my answer correct? No, you don't have to be in that position. Ambiguities is something that jurisprudence is there, because as you can recall, the first class, yeah, remember the seven blind person, every one of them is right, but at the same time they are also wrong. So no right or wrong answer when it comes to jurisprudence. So be able to release yourself, yeah, but it has to be by virtue of the jurisprudence. Questions? Anis, okay, Anis? Tak, kalau
Sorry.
tak, I think you are the only one who is asking question. The rest, macam mana? Kita ada 32 orang ni,
So I
excluding
have a
me.
question.
Yes, Din.
Hi, sir. For example, in part, he
Yeah.
explains on primary and secondary rules, but in our syllabus, he also we also have the Devlin and Hart debate
Mm-hmm.
on morality. So will that idea of Hart still be relevant?
It's okay.
Can it also be used?
Yes, you can use any
Janji
of
in
the
syllabus,
jury.
right, sir?
Sorry, Sophia. Cakap sekali lagi.
Janji in syllabus kan? Sebab
Dengar.
Hart also talks about law and morality.
Yes.
Hello?
Hart talks about law and morality, right?
Yes.
Ah,
So that
so
would also be relevant, although it's not in primary and secondary rules.
yes.
Oh,
Because
okay.
actually Hart kan dia macam ni lah, macam mana saya. I just now I dengan dia orang kejap. Dia macam ni tau. Allah. So Hart, he talks about primary and secondary rules. That is his model, right? The model, he says that in order for any law to be considered as valid, the law or the legal system is considered as valid, they must be comprising of a primary rules and secondary rules. They have to work together. So when you have a primary rules, definitely these primary rules, which is the rule of obligation, you are to do whatever the law says so. It has to be followed by the secondary rules, rule of recognition, rule of adjudication, kan? Lagi satu apa dia? Rule of change, adjudication dengan recognition. Okay, so you have to have that. However, you look at the blue area, we were talking about the morality of the law. He says that even though the structure is there, however, if you look into the structure, you akan nampak the morality of the law, the moral element of the law. Contoh, kita ambil apa example yang kita boleh ambil okay, kita ambil primary rules, kita ambil penal code. Secondary rules apa dia?
CPC.
CPC. Apa CPC? Dia kena ada 3 requirement tu kan? Rule of recognition, rule of change dengan rule of, siapa yang dah baca?
Rules of adjudication, sir.
Adjudication, recognition
Adjudication.
dengan rule of change kan?
Yes, sir.
So, mana kita ada tak law to support these three that represented these three in order for these three to support the primary rules. So but you kata tadi CPC, right? So when it comes to CPC is a rule of recognition of the primary rules, because the primary rule says that if you commit a murder of a person willingly, that is under section 302 of penal code, sentenced to death. So how do you sentence a person to death? There will be rules, procedures for us to find that particular person is having the actus reus mens rea in order for that person to be found responsible for the killing. Now, if you're talking about killing itself, does it reflect a moral virtues or a moral punya foundation? Because killing is the prevention of a behavior that is universal in that particular society. In a way that the primary rules reflects the moral standard of the society, which is considered as natural. We cannot run away from the natural element of the law. This is what he says. Kalau you baca dia punya writings on his idea, then you will discover that betul juga kan. If you're talking about killing of a person with intention, is a prohibition of an act of any member of the society, which is actually in line with the principle of right to life, which is, kalau you tengok federal constitution, right to life is actually the principle of natural law, whereby it conforms with the society, or bukan society lah, kalau society kita boleh, society can be different in their opinion, but it reflects the common understanding of the people in any society. You know, do you have a law that says you can kill someone in any countries throughout the world? For thousands of years, killing is considered as a wrong, which is natural. We don't want people to kill another person without justification. We cannot have that. Kalau kerajaan nak bunuh orang pun, dia kena bunuh orang by virtue of the law. Remember T. Chempo? So when the court comes in and say that the law that they punish, or the law that they use in order for them to kill people, was null and void, then suddenly they were so afraid, because they have been killing people under a law which is not valid. So they quickly ran to the parliament and try to, try to validate, backdated the law in order for them to be, not caught with the situation whereby they kill people without the law. So nobody in our country can kill anyone without the justification of the law. And that law, if you investigate, it does have the element of natural law or morality of the law. Kalau you tengok the application of the court system when it comes to application of the primary rules under the secondary rules, whereby the element rules of adjudication kan, rules of adjudication, kalau you check in detail, they would be going along the line of natural law, because no court is going to be different from another court. Tengok, dia ada yang statement that you treat the case alike. You tak ada lah beza antara court, when it comes to apa rape cases. There is no differentiation of a court from one court of, say, for example, High Court of Melaka and High Court of Johor, High Court of Sabah and Sarawak. They do not differ in their application of the law, which is considered as something that is moral, that is natural. Nampak tak? Even though kita pakai model had sekalipun, had kata, if you go and investigate the model that I am promoting, you will only you will also discover the application of the natural law, which is considered as moral. Ada dalam discussion kalau you baca, okay. Bacalah kalau you baca, you will be able to see how to justify that. For the rest, what we need to do is to be able to present a jurist. You cannot be writing your answers by not referring to jurists. You have to your basis of your answer must be from the jurist. So once you provide the jurist, irrespective whether you agree or disagree, you have to see the thing from the jurist itself. Sophia, did I manage to answer your question just now?
Yes, sir. Very clear. Thank
Yeah.
you.
Kalau tak clear, just you can argue with me and say, I disagree. I think I want that kind of things. My guru Prof Shad, dia kata, if you go to the extent that you are able to come up with a perspective that goes against the norm, you are going to get the higher marks as compared to just following the law. Kita tak nak jadi orang yang pak turut. You are not to follow me. You are not to follow the jurist. You are to acknowledge the differences. But these differences you are to utilize and make up your own opinion. That is the most important thing. However, your opinion does not come straight without justifying your answers or argument from the basis of jurists. Maksudnya itu kita tak boleh kita tak boleh lah pandai-pandai nak come up with your own opinion without relying it under the basis of jurists. So you boleh gaduh-gaduh, you boleh discuss, compare and contrast. You kata mengarut lah Austin, I would prefer hard, and then tapi hard pun sebenarnya tak berapa power. I would like to look at Finins, because Finins, they are in line with what they call it, Akinas. So you can jump from one place to another. If you can do that, that is even better. But for those yang takut-takut, yes, good. Kama.
I have a clarification to make.
Yes.
Even though John Finnis has not exactly the same idea as Aquinas, even though his idea is based on Aquinas, it's not exactly the same, right? Where for Aquinas, where a law is unjust, he does not consider that law as a law anymore. However, for Finnis, even though the law is unjust, he says that we have to obey the law because we have the moral obligations to obey it. But we can criticize the law in private, but we still need to follow the law because of moral obligations. So it's not exactly the same as Aquinas, even though it is based on Aquinas, right?
Yes. So kalau Aquinas, dia kata memang betul pun, lex injusta non ex lex kan. Unjust law is not law. However, Aquinas pun did argue in saying that even though he says that a law is unjust, you have the moral obligation to follow the law. Even Aquinas pun cakap macam tu. In a way, there is a similarity between Finins dengan, because Finins dia ikut Aquinas. Aquinas pula dia ikut they ikut Aristotle, Plato and Aristotle. Whereas kalau you tengok Plato, Aristotle, dia orang dapat dia orang punya ilmu daripada Socrates. Because Socrates pun walaupun dia nak kena bunuh, dia kata tak apa, they argued to him saying that why you have to makan racun tu. You can always say sorry and then vanish to an island. You still can survive, right? So, but he argued, he said, no, all this while I have been respecting the law, you know, and if the law has already helped me all this while, I have gained all the benefit from following the law. And then suddenly I disagree with a law that imposed on me, and I say that the law that is imposed on me is not fair. I don't want to follow it, and I declare it as unjust law. Then tak boleh lah. Just because you are not happy with something that happens to you, and then you start to cry unjust law. Whereas all this while you are gaining all the benefit from the law that has been created. Nampak tak dia punya rentetan ataupun the link between them? But they have slightly, as what you said lah, slightly different punya argument. Macam Hart dengan Austin, nampak ada similarity, but Hart is a soft positivist as compared to Austin, which is hard positivist. Dia memang hardcore lah. Question. Kamal okay tak tadi? Cari dia punya differentiation punya element.
Yes, sir. Thank you.
Okay. The rest? Anyone else who have any questions? You have to ask question, otherwise if you were to sit around and listen to others, I have no idea how far your understanding is. By Sophia, Kama, and Anis able to ask question, which is very good. Mujahid, you are silent. Normally you be asking question. Apa yang selalu tanya? Anis, you. Brian, lama tak tanya. Yes, Ahmad.
Saya nak tanya something about meals.
Meals, okay, right?
Kan kalau ikut meals punya principle regarding harm principle, they explain yang merely offend others does not mean it is unjust.
Betul.
So because the term harm to itself sebenarnya adalah vague, depending on the country and the cultures.
Betul.
So hence adakah the unjust law to itself can be differ depending on the country? Like for example, Asian culture might consider restriction on public display affection to be just, but orang consider it as cause a harm to the public. Tapi Western country consider like PDA ni macam something as a norm. So adakah harm principle ni sebenarnya flexible depending on the citizen and also the country?
Yes, it is. Kalau macam you argue tadi kan, we have one practice of kissing in the public, right? Over in the Eastern countries, it is not considered. It is considered as going against or harming the principle of the society or the right of the society to have a situation whereby we don't want all these kind of things to happen right in front of our eyes. You want to be free from these practices. So, for example, dekat Penang gitu kan, yang katanya dia orang mandi bogel dekat dekat pantai.
Tak nak kahwin tu.
So for the Western people, they say that is normal. It depends. So it depends on the element of harm. So harm does not go to the extent of actual physical, but towards the right of a person. You are harming towards the right of the person that is considered your neighbor lah, somebody that is going to be affected by your act. I dah campur dengan apa thought pula. Tapi basically that is what it is trying to say. So betul lah Ahmad, if you were to apply it, then you will say that different countries, different societies, they see the implementation of meals as different. So you can argue, you can present your argument just now, and to say that even though it seems like Mills is saying the concept is like this, but the concept application of the concept is slightly different depending on the countries and depending on the society.
Okay, saya faham.
Faham Good. So you can do that when it comes to exam. Oh, ada soalan. Does anti-hopping law just or unjust? Because at one perspective, it is just because it upheld the freedom of association under Article 10 of FCA. But at the same time, also unjust because to allow legislative members to change their party allegiance despite in different party during election. Yeah, what do you think, Ashraf? In a way you can have this kind of allegiance punya issue to portray, but if you were to discuss this, it must be by virtue of jurisprudence. Siapa you nak ambil this discussion of Ashraf? If everyone can see that, right, the question that is being raised by Ashraf, that argument whether anti-hopping law or anti-hopping there is no anti-hopping law lagi lah kan, because the federal court dia kata is uh, up to the member to to jump. So because if you were to have that, that is considered as against the fundamental right. So if you were to have this kind of discussion, it must be below ataupun within the discussion of a jurist. So who do you want to talk about if you want to bring out the avenues of anti-hopping law, which is tak boleh lah kita panggil anti-hopping law because there is no law, right? The act of a person jumping from one group or one party to another. Siapa agak-agak you nak discuss?
How about finish?
Kalau you nak ambil finish pun boleh. Kalau you nak ambil hard pun boleh. You know, kalau you nak ambil Austin pun boleh. Because there is no law. Kalau you ambil Austin dengan hard, yeah, hard is talking about primary laws. There is no primary laws in this situation. Ataupun you can put primary laws in terms of anti-hopping law. There is no obligation for us to follow that. However, you can put also at the same time the law that we have, which is the federal constitution, about the freedom of a person to move from to associate from one person to another or one party to another, that can also be discussed. Kalau you nak ambil meals, yeah, you can say that I can go anywhere I want as long as I did not impact or harming the rights of the other person. Because the right of the other person, you kata, memang betul pun dia by jumping to another group is actually harming the other person, but to what extent?
Sir, bukan ke dia harm the voters?
Yeah, they harm the voters. Tetapi that does not restrict the voters to come and appoint somebody else to be in the position that they are able to elect another person when the time comes. You know, there is no restriction of a person not to be able to to exercise their rights. In a way, apa orang kata, macam macam tak adil lah, macam dia apa orang kata backstabbing lah kan. Tapi backstabbing is the right that is given under the law. Unless kalau you have a law that says that the infringement of that particular person's right is clearly identified under the law, then okay, you can find in. For example, yang tadi Ahmad katakan, kissing in the public. Is there a law that we have that restrict a person to kissing in public? Either yes or no?
Ada sir.
Ada. Kalau ada, then that right is legal right, bukannya kata moral rights. We are not talking about moral rights. Opinion of a person whether the act is okay or not. We are talking about legal rights. So if you can provide a legal rights, then you can bring the legal rights and challenge the action of a person, that he can say that I can do whatever I want, I am doing under meals, as long as I don't harm other people, then it should be okay. So you can bring the argument saying, no, you are actually harming me, my legal rights. Then Mill's argument in that particular situation shall not stick lah kan. Macam ni, kalau dia nak lompat, you boleh kata apa? Tak boleh kata apa kan? Because you have no right. Unless and until kalau you ada anti-hopping law, which is actually going to go against the fundamental liberties pun. So any law akan mati kan? Ahmad? Yeah, you about to say something.
Kalau ikut artikel 10, sebenarnya ada exception dekat
Yes.
Freedom of association.
Mm-mm.
Kalau ia infringe the public morality and also something along the line macam tu lah. Sebenarnya boleh, parlimen boleh pass the law on anti-hopping law. Tapi disebabkan tak ada lagi, sebabkan parlimen tak pass this law lagi, so basically orang boleh lah lompat mati.
Lagi
Sebenarnya ada dia clear dia punya apa kata, anti-hopping law tu orang kata boleh buat sebenarnya.
yeah, and the court is not able to come to save the day, because you cannot expect the court to be the one that to decide, because we are talking about a statute, you know, a law that is coming from parliament. So the courts cannot play an active role. They are there to settle dispute as and when there is no law. But the actual law or the lacuna has to be resolved by the parliament. So if say for example parliament pun obviously tak nak create, because they don't want to be, you know, tak ada, dia tak nak terikat themselves. You know, they knew this is politician punya game, so they want to be able to seduce or to to ask another person to join them, because it works both way tau. Kalau you member of parliament, obviously if you want to be in power, obviously you want the numbers. So if you want the numbers, obviously money politics come in, and you want to be able to make an arrangement behind closed doors, macam yang dia orang buat hari tu dekat apa nama
Ceratan saya.
So they can do some kind of talks or arrangement. If kalau kita join coalition, you ambil bahagian ni, I ambil bahagian ni, the other person ambil bahagian tu. So they can do that manipulation. So that is the politician punya game. I know we at the lower part as the citizen actually orang kata kena tipu lah, outright kena tipu. But it seems that they are not going to go there. I think so lah. That is kenapa nak kena bunuh diri. They don't want to themselves to be tied by the law. Tengok contoh yang paling clear, kita yang kerja kerajaan kena sign in untuk sign out. Kalau your parents yang kerja kerajaan kena pergi kerja, kena pergi sign in and sign out. Dia orang pergi parlimen under our money tau, people's money. You know, they are getting money from us to go to the parliament and do their job, but they do not have uh, a clock system that they are to clock in and clock out. Whereas everyone must be there when the parliament is in session. You impose a law towards all government servants, 2.5, 3 million of us, and then yet you don't follow the law. Kalau kita tengok discussion in parliament, berapa ramai sangat yang ada, kerusi kosong penuh. You know, you cannot use the argument and say, oh, I have to be somewhere else. No, parliament session is everyone must be there. It's work. So if you say that the application of the law is throughout for everyone, then you have to be at your workplace, which is parliament. The same thing when you apply COVID punya ruling. Just because you are a member of parliament, that does not give you the right to disobey the provision of the law. You cannot argue and say I am member of parliament, so I have immunity. Cannot, because whatever happens yang sekarang COVID yang beribu setiap hari is because the election dekat Sabah. They were the one who brought it back, and before this kita tak ada cluster Kenting Highland, tak ada cluster Cameron. We were at kita tak ada pun cluster-cluster sebelum dia orang ada election. So the election is the one that caused the problem to our society, even death to people. Dia orang are silent. They are running away and saying that, oh, bukan, it's not me. Whereas memang clearly it is the election of Sabah. Now Sarawak is coming in, right? So just because the constitution is saying that there must be an election for a certain date, that is not mandatory. You can still go to the parliament and change the constitution, because this is a situation of life and death to the whole nation. Especially yang sekarang ni punya virus punya mutation, right? We have that 7 times faster. So obviously, are you going to expose us to another cycle of the virus just because you want to follow the law? Amboi, setengah benda you follow the law, setengah benda you tak follow. What is this? You know? This is some of the argument that you can bring it up if you want to bring it up, but it must be under the virtue of discussion of jurists lah. So you must be able to manipulate your argument within the jurist of your choice. Kashifa kata, given text, they are part where it states that there are 2 questions arise from part of heart, where he ought to use outside obligation assertion, and he ought to make only a-sided appeals, if not quite understand. Macam mana? To what extent that you understand in terms of outside obligation? No? To what extent that you faham? Anyone bila nak baca No punya statement tu, do you know what she's asking? Kalau outsider dengan insider. Okay, Lani macam ni lah. Kalaulah kata kita nampak traffic light, right? Kalaulah kata alien datang kat Malaysia, dia tengok kita punya society bila sampai kat traffic light, kita berhenti. Right? Dia nampak rota merah, berhenti. So to them, to the aliens, they see us from an outsider. An outsider, they wouldn't understand why do we have to follow the law. Dia cuma boleh faham kata kalau bila ada objek merah, semua orang suddenly akan berhenti. Kalau ada the color of the light is green, everyone start to move. But they wouldn't be able to understand the reason why we follow the law. Some people follow the law because they fear of being being summoned. by the police. Some people obey the law because they use their common sense in a way that they want traffic to be flowing, you know. And some people just use their common sense to look at the law that they feels that the law is going to benefit them. You can only understand the law if you are within the society itself. You cannot be able to understand if you are not within the society. Say for example, uh, DDA. Okay, DDA is a law that we implement in our society that anyone who brings in drugs, certain amount of drugs, can be punished to. They are mandatory. We are going to take action against them. It will be mandatory death. Okay, that is our law. From an outsider looking at our law, they will say that, apalah, there is no morality in terms of that. They can be judgmental about our law, but they wouldn't be able to understand why we have this law in our society. The law that we have in our society is trying to to have a good outcome, which we ourselves are able to understand why. Because our society in Malaysia wouldn't be able to understand uh, apa orang kata, nak pakai drugs tu bila, ataupun normally kita abuse anything yang kita ada, kita akan abuse. Daun ketum pun actually benda yang elok untuk kesihatan, dah disalahgunakan. You know, everything semua disalahguna. Gam untuk kasut dipakai untuk nak sedut. So memang kita ni ada penyakit sikit lah kita dekat Malaysia ni. Anything that is being prevented from us to use, kita akan pakai. So that is the question from the internal punya or within the society. Only then, if you are inside the society, then you can understand the implication of the law, the need for us to follow the law. Yeah, the understanding comes from understanding the from within the society itself. You have to be within the society in order for you to understand. You cannot be looking at the law from the outside punya situation. Maksudnya internal and external ataupun from inside or outside. Boleh no? Faham
Boleh,
tak?
sir. Much clearer now. Thank you, sir.
Clear okay, kalau you baca lagi you akan nampak insyaAllah.
Oh, okay, sir.
Alright. Okay, so guys, ada lagi soalan?
Sir,
Yeah.
I have one question.
Yeah,
Tadi
good.
based on what you said earlier, you said like unjust law is actually an infringement of legal rights, right? But is it subjected to only legal rights? Because the way I look at it is that I think the reason why it is called as unjust law and people oppose to that so much is because their rights are not protected by the law. So I think it is almost impossible to actually go against unjust law by stating another law that will protect our rights. Because I think that a lot of us think that the law is considered as unjust because the legal rights that are not protected in that law
Okay.
and any other law.
Farah, when you say I think, you must be able to go behind the jurist in order for you to argue that. You cannot be presenting and saying that this is the situation and I and many others would see it differently. You know, what you're saying just now must be based on jurisprudential punya perspective.
Yeah, I understand, sir. But
So
I
which
actually
one?
referring to the statement that infringement of legal rights, right?
Mm-hmm.
Because um, I think it is quite the opposite.
Mm-hmm.
For example, in Malaysia, we actually ban um, law for abortion.
Mm-hmm. Mm-hmm.
But for some people think that rights for abortion is their rights, but
Mm-hmm.
this right is not protected by the law. So
Mm-hmm.
I think it is almost impossible to actually um, go against unjust law by stating another law
Mhm.
when it doesn't exist at the first place.
Itulah yang I kata tu, I risau bila you come up with this so-called logic, right? When it comes to looking at a law to compare and contrast, it must be by virtue of the jurist itself. You must bring it within the discussion. So whose opinion that you are looking at? It must be critical analysis of a jurist. If you want to compare between A and B, between Finins and Austin or anyone, yeah, you can do that. And you can argue your opinion just now. But by yourself, you are saying that you are coming out with an example of abortion, saying that some society obviously do not agree with it, but it seems that or certain society agree with it, but since we do have a law that restrict abortion, therefore we have to follow the law, which is considered as unjust kalau kita nampak dekat US kan. US is allowing a person to do abortion, right? Because that is their fundamental right of a person of their body. So it has to been it has been secured by virtue of the Supreme Court punya decision. So in order for you to discuss that, it has to be discussed under a jurist. Boleh tak, Farah?
Faham?
You faham So never anyone in our class do not raise an even though you are valid in discussing the issue, which is actually something that is prevailing ataupun something that is clear. We cannot do that under jurisprudence if we don't have any jurists to back up our discussion. Boleh? Nobody is to have their own opinion. I myself cannot have my own opinion unless and until it is discussed under certain concept or certain model of a jurist. Boleh insyaAllah Farah ya?
Boleh, sir.
Okay, next last question. You know why, Farah, I ask you to go under jurist because whenever exam, many of the candidates, the previous candidates, dia orang banyak bercakap tentang dia orang, apa dia orang punya opinion. And then even though the opinion is legal punya opinion or argument, they would try to base their argument by virtue of any laws, yeah. For example, federal constitution or cases that they bring in. So it would not be a jurisprudential punya argument. It will be macam you jawab jawab soalan constitutional law 1 or consti 2 punya answer. So no jurist that is being discussed. If there is no jurist being discussed, then there is no marks to be given to you. Itu bahayanya. Bila buat jurist ni, there is a tendency that you are going to do based on your legal insight. Your legal insight is not to be acknowledged. Good questions, Farah ya. Any
Faham.
questions? Faham
Hmm.
Kalau you bring it by virtue of any jurist, then your argument becomes valid, suddenly become valid.
Sebab I'm actually asking for clarification because like from the statement that you made regarding infringement of legal rights, because I think I'm asking whether it is subjected only to legal rights or it would be
Legal rights.
Bawah
Siapa
law.
punya argument ni yang bawa masuk legal rights?
Tadi saya cakap waktu you responding to Ahmad Zakiuddin.
Ahmad cakap pasal finance kan? Sorry, finance pula.
Pasal
Yes, sir.
You cakap finance ke siapa?
Meals.
Meals. Then we are talking about by virtue of meals. Then the discussion is considered as valid. Because whenever you answer the question, you must bring in the juries in order for you to discuss the position of the law, whether the law is legal or not, and then the legal obligation of the law by virtue of the perspective of the juries. So kalau lah kata kita tak present the juries, then obviously we cannot have a uh, apa orang kata independent opinion. It must be by virtue of the juries. Remember guys semua? Farah, so sorry lah because apa yang you punya relationship tadi, the argument of what I said, I was discussing it under meals. Okay, I think I don't want to hold you back. Dah pukul 10 dah ni. So if there is any questions that you want to ask, you can always do so by personal message me pun boleh, and asking within the group pun boleh. Ramai juga yang tanya individually because they feel malu lah apalah, Good. So guys, thank you so much for coming to class. So we will see each other in another makeup class. Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
Assalamualaikum.
Thank you, sir.
Thank you, sir.
Waalaikumsalam.
Waalaikumsalam.
Everyone have to go out in order for me to end the recording.